Welcome to another segment of What the Heck is Going On? I am your host, Jeff LaFrance. Today we are going to Honolulu, Hawaii. Well, put away the suntan lotion. This time you're going to get burned in court, not on the beach. And SPF 1000 won't help you. Our story today is the case of the missing court documents. Today you'll be getting a lesson on how our court system really works. Well, in this case, doesn't work, at least not for you. We're going to court today in another attempt at Show Me the Real Birth Certificate. As many of you know, Orly Taitz has been embroiled in a heroic attempt for all Americans to see what we have the right to see, the truth. She has been traveling all over the country in our behalf, and so far we are all being denied a fair opportunity to know just what is the real truth about the birth certificate of Barack Hussein Obama. As citizens of this country, we have the right to know the truth. Now, let's go to court.
All rise. Court is reconvened. You may be seated. Calling civil motion calendar number 4, civil number 11-11731. Dr. Orly Taitz Esquire versus Loretta Fuddy et al. For emergency motion for rehearing motion to stay final order pending rehearing. Appearances, please.
Orly Taitz, Attorney Orly Taitz, plaintiff pro se.
Good morning, Your Honor. Jill Nagamine, Deputy Attorney General. Present with me, Rebecca Quinn, Deputy Attorney General, representing the Department of Health. Before we begin, Your Honor, I do have objections to the media coverage, and I would ask it be turned off while I make those objections to the court.
All right. Turned off while you made the objections, and then we can address that.
What just happened, you might ask? Well, Deputy Attorney General Jill Nagamine just made an attempt to banish the First Amendment. Her reasoning was in a response to a message I sent the Chief Elections Officer, Scott Nago. And here is what I said to Mr. Nago. Dear Mr. Nago, my name is Jeff LaFrance, reporter, producer for Cable Channel 8 News. I'm aware Attorney Orly Taitz has filed a petition to the court for an emergency hearing on the matter of eligibility of Barack Obama, on the grounds he does not meet the requirements to be on the ballot, and has submitted possible false documents in support of his eligibility. I urge you to respond to the emergency petition. A copy of this petition is enclosed. As a registered voter in Hawaii, I believe it is your sworn duty to uphold the laws of this state. I urge you to do your duty as sworn by you. I also urge you to appear in court November 30th, 2011 at 10 a.m. in the court of Judge Nishimura, 777 Punch Bowl Avenue, Honolulu, Hawaii. I will be reporting on this case and would like a response from you in this matter. A no response could surely be seen as an act of complicity. I hope this is not the case. Below, you will find a copy of the petition. I have also included it as an attachment file. I look forward to your response. Sincerely, Jeff LaFrance. After the court ordered the camera to be shut off, Deputy Attorney General Jill Nagamine went on a tirade. And this is what one witness and well-known author Mickey Booth had to say. The Assistant Attorney General's conduct was shockingly inappropriate, highly unprofessional, and very unbecoming her position. When she personally attacked the cameraman, that would be me, and Mrs. Taitz by calling them birthers and questioning the cameraman's credentials, when it was her boss's credentials in question. But the Assistant Attorney General stooped to personal attacks and set a tone of extreme animosity towards Attorney Taitz. The Assistant AG went on to say the cameraman should not be allowed to film because he is cut from the same cloth as Attorney Taitz. Well, Jill, if that cloth is the American flag, I will take that as a compliment, even though it wasn't meant to be one. I am not just the cameraman, Ms. Nagamine, I am also a patriotic American. It shows me where your loyalty lies that this bothers you. Does anyone see the irony in this? Obama's attorney questioning my credentials? Can you say audacity? Well, I'm sorry, Ms. Nagamine, but Rachel Maddow couldn't make it, and you're stuck with me, well, at least for the moment. And after this, I probably won't be allowed back in that courtroom again. Well, I do have to say, it is to Judge Nishimura's credit that she did not allow Assistant AG Jill Nagamine to banish the First Amendment in her courtroom. For that, she is an honorable woman, and I thank her for that. Now let's get back to the case.
You were trying to file an amended motion.
Yes, and
Under what rule?
I will argue today on the original motion.
Thank you. Go ahead.
Um,
And as to the original motion, your motion for rehearing, are you coming under Rule 59 or Rule 60? Motion for reconsiderations are very limited in
I
terms of the
believe
court's review.
under Rule 59E, you are allowed to bring motion for reconsideration where there was an error of law and fact and manifest injustice. So I would like to clarify that it's going to be under 59E.
Now, has a judgment been filed?
Not yet.
Under 59E, a motion to alter or amend judgment number 1, has a judgment been filed? Because there's no Rule 59E in terms of the basis of your motion if no judgment has been filed.
Okay.
I don't see any judgment having been filed, and I'd like to seek
Okay,
clarification
then
from
I
the
would like,
agency.
Your Honor, then I
No
would,
judgment's been filed yet?
No, it has not, Your Honor. I thought
Then
it might
I-
be best to wait for today's hearing.
then I would like to clarify that I'm seeking to set aside and reverse an order and not a judgment. I believe under Rule 60, I can,
There's particular subsections under Rule 60 in particular.
can I provide a supplemental brief and argue, this, Your Honor, this is an important issue.
No,
And
Ms. Tate, it's an important issue, so the court's decision is important. The
I
court's
will be
decision has to be dependent upon what you're asking the court to do and under what authority.
I'm asking the court to reconsider an existing order that was issued on after the hearing on October the 12th due to the fact that new evidence came forward and
Okay, so, clarify, you're proceeding under Rule 60B2, which is newly discovered evidence which by due diligence could not have been discovered in time to so move under Rule 59B. And let me take a look at your reply memo to see.
in reply,
Excuse me, Your Honor, we did not receive a reply.
Okay.
It was sent.
That's correct. The reply you have filed is a reply to opposition to amended emergency motion for rehearing. Now, as I informed you, Ms. Taitz, if you're seeking the court to consider an amended emergency motion, then pursuant to both the Circuit Court rule and the Hawaii Rules of Procedure, we need to set a new hearing date.
Then I will provide the reply in my oral argument. I will provide reply to their position. They have filed an opposition to the original motion. However, I do have proof of service showing that the amended motion was received by the court and the office of the Attorney General. I'm greatly concerned that even though the motion was received by the court, it was never docketed and it was never given to you. And I'm concerned that if I'm submitting yet another amended motion, the same thing might happen.
Your amended motion needs to put in a new hearing date.
But it was received by the court.
No, but Ms. Taitz, your amended motion needs to put in a new hearing date because it's actually a new motion.
That's true, but the question is, what is going on here? The motion that was received by the court, that was received with certified mail, disappeared, was never done.
Well, let me stop you here just for a second. So what is Orly talking about is the case of the missing court documents that were delivered to the court and to Assistant Attorney General Jill Nagamin's office. But they are nowhere to be found. And here's a copy of that delivery receipt that was signed by people in those offices. To her credit, I do not believe that Judge Nishimura had anything to do with the disappearance of those documents, but she may want to have a talk with her court clerk. Because Jill Nagamin is claiming she never received these documents, Orly Taitz is not going to be allowed to discuss the contents of those motions and not be allowed to bring forward any of the points or evidence that she flew thousands of miles to present.
No, but Ms. Taitz, you're mentioning newly discovered evidence in connection with your amended motion, which is not before the court.
So I'm providing newly discovered evidence in connection with the original motion.
No, you cannot, after the fact. When you present your motion, you have to put in your motion all the legal arguments, all the facts, whether it's exhibits, affidavits.
Newly discovered evidence developed after the motion was filed. And
So the basis of your original motion was not based upon Rule 60B's.
it's 60B, but also there is new evidence.
No, but the basis of your original motion was not based upon newly discovered evidence, 60B2.
It's based on error of law, based on manifest injustice.
Because Ms. Taitz, if you want the court to consider newly discovered evidence, it would be the subject of an amended motion with a new hearing date.
Your Honor,
So I'm giving you a choice in this case.
Your Honor,
I don't know what else
Your
more, because
Honor.
I'm hearing that you have newly discovered evidence only from yesterday, but your original motion made no mention of it.
Your Honor, I'm asking Your Honor to allow me to submit this oral motion and give the Deputy Attorney General an opportunity to file an opposition at a later date. But considering the fact that both parties are here and logistical difficulty of bringing this to court, I'm asking Your Honor to provide the court with additional evidence, with Deputy Attorney General reserving her right to respond.
So in other words, do you wish the court to consider your amended motion as a supplement to your original motion?
Yes.
All right. Madam Attorney General, now that we've gotten that clarified, Ms. Taitz seeks leave of the court to consider her amended motion with the newly discovered evidence contained therein as a supplement to her original motion, giving you leave to also supplement any opposition. Therefore, the court would then be taking the matter under advisement and issuing a minute order to that effect.
I would object to that, Your Honor, because I have not had an opportunity to prepare argument for her amended motion,
And
discovering that was not on the court's calendar.
And to that extent, then the court cannot hear any further argument in this case, because then they have not had the opportunity to look at your amended motion, look at your newly discovered evidence. So they're at a disadvantage in that you wish the court to allow you leave to argue from your amended motion, which is not on the court's docket. All right, go ahead on the original motion.
Oh, yes, Your Honor. In the original motion, probably the most important issue is the issue of the technique that is used to authenticate documents, authenticate and verify documents.
And that's containing argument number 2.
Yes, I believe it's number 2. The main issue is that the defense has stated, and it is on record, that in the state of Hawaii, the documents are being verified and authenticated with one word, yes or no. After the hearing, I have done extensive research, and there is no such rule of authentication with a one word yes or no. On the contrary, what I did find that in elections law of the state of Hawaii, it does state issues of elections fraud as well as petitions in regards to change of rules can be brought under 3-171-3, and it specifically states that it is done in according to procedures set forth in Chapter 91. Chapter 91 in pertinent area states documentary evidence may be received in the form of copies or excerpts if the original is not readily available, provided that upon request parties shall be given an opportunity to compare the copy with the original. So it's actually the opposite of what was stated by Ms. Nagamini. Additionally, Hawaiian Elections Law, Section 3-172-130, access to election documents, states that...
Objection, Your Honor. None of this is in Ms. Taitz's original
Ms.
motion.
Tate, is this in your original motion?
In regards to the elections law, I did not state elections law, but I did provide 91-10-2 as the governing law in the state of Hawaii. And as a matter of fact, at a prior hearing, Ms. Nagamini has stated here in the state of Hawaii, if one were to ask, was this person born here, the way it is done done by an official saying yes or no. Yes, we have a record. No, we don't have a record. Ms. Nagamini didn't even give me a courtesy of citation of where she got it, which section, which law, where did she get it from? She just made up something on the spur of the moment, October 12th. So I'm stating that there is no such law; it just doesn't exist. Specifically, in regards to elections.
Objection, Your Honor. There's no mention of elections
Yeah,
that I can find in the original
Ms. Tate,
motion.
you need to confine your arguments to your original motion.
Okay, as Ms. Nagamini has stated that the answer is a yes or no. Yes, we have it in the vault. No, we don't. The question is, how do American citizens know that there is anything in the vault? If we have a situation where an official, a state official, is releasing a document which is, according to expert after expert, shows to be a forgery, and the same official is the one who is doing authentication, how do we rely on such authentication? How do we know that there is anything in those vaults? Why the state of Hawaii even has those vaults? As I stated previously, Mr. Obama has signed a release stating that his original birth certificate can be provided, can be released to the public. He has waived any rights to privacy, and there are no further rights the moment he has given such release. Moreover, Hawaiian Rules of Evidence 502 state that if fraud is committed...
Objection, Your Honor.
It's not contained in your original
not in the
motion.
original.
It's hard for me to tell what's in the original motion because I have already filed, as I said, amended motion and
And that's why, Ms. Tate,
Yeah.
I've given you the opportunity and the choice of returning and fully arguing an amended motion with a new hearing date.
Okay, then I will submit another amended motion. Apparently,
So, Ms. Tate, so when you say you want to submit another amended motion, so are you withdrawing this motion and then you plan to file another motion for rehearing
Yes.
such that you can fully brief the
Yes.
issues with whatever documents, exhibits, etc.?
yes, Your Honor, I will do that. I also...
So the question that's before the court is that do you seek to withdraw your present motion so that you can file a new motion to get a new hearing date?
Yes, I'll do that.
All right. Nothing further. Court stands in recess. Motion has been withdrawn.
All right.
So there you have it. Once again, we are denied the simple truth. This is how our court system works. And again, to her credit, Judge Nishimura is going to give Attorney Taitz another chance to put her case before the court. She is allowing it to go forward. And personally, I don't think she had anything to do with the missing documents. But I do think she needs to have a long talk with her court clerk. As for the personal attack on myself and Attorney Taitz by Assistant Attorney General Jill Nagamine and her attempt to stifle the First Amendment, well, you heard what Mickey had to say. It was very unprofessional, as well as, I might add, a disgrace to her office. Believe it or not, we the people are paying this woman for her services. I ask, what are we paying for? To hide the truth from the American people? This is America. We have a right. And I'm not just talking about Miranda rights. The right to know the truth. Well, at this point, Chief Elections Officer Scott Nago has declined to answer any questions or make any comments about why his office has refused to accept certified mail from Attorney Orly Taitz about the petition I was excoriated for in court. Well, Attorney Taitz has spent a small fortune, flown thousands of miles, spent untold amounts of time, and we, America, still don't know the truth. We have a problem. And I urge all Americans to do your part, do your duty as citizens by contacting your representatives, your elections officer, and demand they honor their oath of service to protect and defend the Constitution and do what they tell other countries to do, and that is to hold fair elections without corruption. Demand action and tell everyone you know to do the same. Before I go, this is what eyewitness Mickey Booth also had to say about what she saw and heard that day in court. She said, "My heart sank when I realized the court had sabotaged Mrs. Tait's case by claiming that he did not have received her submittals for rehearing, even though she showed proof that she had sent it. So where did it go? Mrs. Tait's submittal to Nagamine also was not in the docket because they refused it, according to the courier, who remembered it was strange that they refused it because one letter in Nagamine's name didn't look right. I felt sick from fear at the depth of corruption I witnessed." Well, Mickey, after examining the evidence, someone at Nagamine's office did accept it, and here's the receipt. I can't read the name, but someone in her office accepted one of the 2 packets. Where are the missing documents? This will not happen again next time. I have confirmation that a retired military officer has delivered the documents personally this time. Sir, you have my gratitude for serving your country once again. Gerald, you are a great American. Well, thank you for joining me, and I look forward to seeing you again on our next segment of What the Heck is Going On? I am your host, Jeff LaFrance, wishing you all the best that life has to offer. And that includes life, liberty, and the pursuit of happiness. Thank you.